Hello, good afternoon everyone. Myself Swapnil Mukherjee. I am a research scholar at the Amit University, Kolkata. And today my topic is, as you can see in the PPT, that is the building block on the postulation of bank guarantee, analyzing the imperils, that is the risk and the role of alternative dispute resolution thereon. Now the thing is, you can also get this PPT along with my full paper. I've created a website that is ppt.inens.com. You can get this and also share feedback after listening my presentation. Now the thing is that we as a lawyers or legal scholars or from the law fraternity, we are on the very lucky side, because either you get a license, you start practicing, or either you join as a faculty, you withdraw salary from this one. But what about those who do real business? If we go to the stock market, people taking doing business. And in India, if we have to do business, the business is not so easy. We have to take risk every day, and there is no formula also that could be can be taught. Like, okay, it's a mathematics formula, you learn this and then you become a professor in the university and you can start doing a business. In India, if you have to do business, you have to know one thing, that is jugaad. Without jugaad, like how to manage the things, you cannot do business in India. In India, if I want to start a new shop, we have to take risk. So one day, a person came to me and asked that, I want to start a new shop, but I want to take some material on credit, but the person, he is in Mumbai, okay, my wholesaler, how I will take? He's asking money from me. I have got his number from my Fupa ka, Mosi ka, Beta ka, say, from WhatsApp, and I have managed that he is a very good wholesaler. Okay, but if I give him money, I cannot trust him. In this situation, what is the solution? Now, the same story I will repeat with my PPT slide. So this is Mr. Pradeep. Now, he wants to actually start a new shop. The program is there and we are all enthusiasts with the startup program. Now this Pradeep wants to start a new shop. He wants to buy material from Mr. Karan, who is actually a wholesaler in Mumbai. Okay. Now how he would buy this? Because he do not. This Mumbai wala, this wholesaler is very kharush. He will not give even a single raw material, even if it doesn't get a penny or some kind of things. Okay. Now in this situation, this Pradeep, when he came to me as a lawyer, I advised him, you do one thing, you go to bank and you use the tool of bank guarantee. Now what this bank guarantee is? Now this bank guarantee is a very good instrument. Okay. So this bank has come in. So you do not have to worry now. Okay. Now in this bank guarantee, what the bank would do is, it would issue an instrument that, okay, if Karan want to buy a material of rupees 50,000, it would issue an instrument in the name of the creditor, that is Karan, that okay, you deliver the material, bank is taking the guarantee. If this Pradeep does not pay, this bank will pay because his monies are flying, it is enough money. Although this is not the situation, because bank guarantee, when you go to take, bank actually will ask for collateral, because वो भी तो धंधा ही करता है ना ultimately. Now the thing is that we have understood this bank guarantee to some extent. The Kerala High Court in 1983, in one of its case known as P.J. Rajpan versus Associate Industry, has explained properly what this bank guarantee is. Okay. Now this bank guarantee is a tripartite agreement where the three parties will be involved. One is the principal debtor, one is who is taking, in my case, Mr. Pradeep, who was this side, the creditor, and the surety, that is the bank. And in this way, even if the principal data in Pradeep, if he would fail to pay the money, then at least the bank is taking the guarantee that he would give that entire money. Okay. Now, as a law professional or from the legal domain, you would ask me, why I'm telling about the bank guarantee? What is it? Where the law is? Is it some scheme of a bank like fixed deposit, or is it something else? So the thing is that the bank guarantee is having a foundation in our law, that is in the Indian Contract Act. In section 126 of the Indian in the Indian Contract Act, it says about the bank guarantee. It says about what is guarantee and what the surety will do if the principal data actually fails. Also, if we see section 127 of the Indian Contract Act, there also it says that bank guarantee is a consideration, because without consideration contract cannot be there. Okay. Now the thing is that we have understood what is bank guarantee. We have understood that bank guarantee is having its foundation on the basis, it has a backing of law. Then what's the problem? Why are you here to discuss about this topic? Because even if this small businessman had got this good instrument of bank guarantee, despite getting this good instrument, there are so many cases are there with the bank guarantee. So what are the risks even after taking the bank guarantee that I want to highlight? The thing is that sometimes what happens, you take bank guarantee and after that, maybe banks are very smart enough. They would write the clause in as in way that once your time frame is exceeded, okay, it will not give that guarantee to the creditor. Okay, now the principal data would suffer. Now the creditor would say, you said you have given me the bank guarantee, then what happened? Maybe there was a time delay of the goods delivering to Mr. Pradeep in that case. Okay, maybe from Mumbai it was delayed, but the timeline was like finalized for 30 days. The goods came beyond 30 days. Now bank is saying, no, I have only have a limited fixed period of time. I'll not give now. This contract has been is a kind of a breach of contract. In the case of breach of contract, or maybe sometimes what happens, the data, the Pradeep in that case has not got the good from Mumbai. Okay, but the bank has realized his the bank guarantee has paid the money to the creditor. In that case, he's not getting also, and he is stuck in some place or the other. Okay, now in this risk situation, now what this small businessman would do again? First, he has taken so much risk and has started a business, and even after starting the business, now again from the bank he would get some kind of legal problem and he has to go to our law courts, and we know how the law courts in India are. The cases are few crores in India now. Okay, and again if a businessman has to go to the law courts and dhakka khaving every time, okay, then what's the solution we as a legal professionals are catering, and for what this conference is for? Okay, now the thing is that this Pradeep went to District Legal Service Authority, because ultimately in small district towns, legal service authorities are the savior for the small business persons who are not having that much income. And over there, the DLS secretary said, you use ADR. If you have the terms in the contract, you use the term ADR. Now what this ADR is? Alternative dispute resolution, which means if you do not want to go to law courts and spend your time, or any other tribunal and spend your time for years, then you have an option of going through the process of either arbitration under the Arbitration and Conciliation Act 1996, or through the process of conciliation, or through the process of mediation, and then resolving the issue. Okay. Now the thing is that bank guarantee itself it's a autonomous document. In jurisprudence we have a principle called doctrine of separability. In the doctrine of separability, even if your main agreement is being termed as null and void, but still, if your arbitration clause is there, still you can go to the arbitration. Like your whole, even if a part of the contract is declared null and void, the whole contract is not declared as null and void. Okay. So ultimately, this ADR mechanism will actually save time. At least within 1 year, you can get solution. It is cost efficient. People or businessmen can actually save their time. So I think that we as a legal professional, the onus lies upon our shoulder to actually make business people understand and to include ADR while we are drafting contract. Okay. So I have also written an oath that we should now take, we as a legal professionals should now take that as advocate and legal expert, I pledge to promote the awareness of alternative dispute resolution ADR. I encourage all to incorporate ADR clause in agreements to facilitate swift legal resolution, elevating India's case backlog. And I think that it's the time of our hour that everybody should take that is ADR oath now to save our businesses, to save our corporate houses. Thank you. Thanks a lot. Namaste.